Hi, my name is Eric Ledbetter. I'm an immigration attorney at Quarles & Brady in downtown Chicago. I'm going to talk today about immigration compliance for employers. And so what that means is there are basically three subcategories of immigration compliance. The big subcategory is what we call immigration benefits. So that would be work visas, work permits, green cards, immigration status for your employees. And some employers, increasingly a lot of employers, have concerns in this area because they're global in nature, or they're recruiting around the world, or maybe just because they've hired someone in the United States who happened to have been born in another country and then went to college here. And so we help companies with that. But mostly today we're going to talk about the other two subcategories, which is I-9 compliance and E-Verify compliance, and then the anti-discrimination side of I-9 and E-Verify compliance, which is something that every company in the United States has to be concerned about, because there's a federal law that says that when you hire a new hire person, you have to check that person's identity and work authorization and then complete the I-9 form. And increasingly in states, there are also state laws that say you have to run that I-9 data through E-Verify to confirm whether or not the person is authorized to work. So currently in Illinois, that's not the law, but companies that have operations in other states are having to contend with that. And also if you have federal contracts, E-Verify comes into play because you're a federal contractor. So why do we worry about I-9 compliance? Well, there's this 1986 law that Congress implemented back in 1986 because at the time there was a problem with undocumented people in the United States, and the concern was that they were coming to the U.S. to get jobs. And so Congress did two things. First, they created a legalization program for the people at that time, back in the 80s, who were here illegally. And they implemented this I-9 requirement for employers as a way to stop the jobs magnet, thinking being that if someone comes to get a job and they're not able to produce documentation to show that they have work authorization, then they wouldn't be able to work for the company, and the word would get out and people would stop coming to the U.S. illegally to get a job. So that was 1986. Didn't work quite as planned, quite as well as planned. And the real reason for that is because the enforcement stopped. Almost as soon as the law was enacted, they just quit enforcing it. So throughout the 90s and most of the last decade, there was just very little enforcement. But that has really changed starting around 2007, 2008. Now there's incredible enforcement and really tremendous fines for I-9 violations. And so the example I give is last year Abercrombie & Fitch got into trouble. They didn't have any undocumented employees. However, they hadn't done any of their I-9s correctly because they made the same mistake on each I-9. And so that added up to a fine of over $1 million for Abercrombie & Fitch. So there are two types of violations. There's the more serious one. That's where you know somebody's not authorized to work, or you just didn't complete an I-9 at all, so you don't know, but you don't know because you didn't complete the I-9. Or you did complete it, but just made serious errors such that it was the same as not having completed the I-9 at all. Those are the more substantive, more serious violations. They generate the higher fine levels. And then there are the technical or paperwork violations. That's where you're really trying. I think a lot of companies are in this area. You're trying, you filled out the I-9, you made a couple of mistakes here or there, and each one of those mistakes will end up costing $110 a piece unless you can get them fixed. And then there are criminal penalties, but those are reserved for the really serious offenders. Typically where there's a pattern in practice where the company is winking and nodding, maybe helping the employees secure fraudulent documents. We've had companies get a van and go down to the border and pick people up that they knew were undocumented and bring them up to work. And so, so there are criminal penalties, but really just for the most serious cases. The thing about I-9 compliance is it puts the employer in a conundrum because you, on the one hand, are obligated to go through this process and look at documents and fill out the form. And on the other hand, you're obligated to do it in a way that's non-discriminatory. The concern when they created this law was that employers would just say, well, this sounds like a headache. I don't want to deal with this. I'm only going to hire U.S. citizens. And that would be discriminatory because there are people in the United States who are here legally and permanently. They're just not citizens, so they have the right to work. And we call those lawful permanent residents, and also people who are here because of asylum. They were politically persecuted at home. They came to the U.S. They were able to get permanent authorization. And so those three categories of people are all authorized to work. And for work purposes, there's no reason to discriminate between them. And so there are some anti-discrimination provisions built right into the I-9 law. In 2013, the Immigration Service made some changes to the Form I-9. And you can look here at the slide at the major changes. What they did was recreated the I-9 form. They made it longer, they added some fields. And so in section 1 of the I-9, they added some fields to take the employee's email and phone number. Not all employees want to provide that though, and it is an optional field. So if somebody provides it, great, most probably will. But if they don't want to, you can't make them, and there's no requirement. So you won't get into trouble if it's not filled out. They also added a field for the passport number and the I-94 number. The I-94 is the card that a person gets when they enter the United States as a temporary visitor. And so they added fields in section 1. These fields must be filled out if they're relevant for the employee. They also added some more space to section 2 so that you don't have to try to cram in a lot of information in those little boxes anymore. And then they made some edits. They really completely revamped the I-9 handbook. And they worked with my organization, the American Immigration Lawyers Association, to redo that manual. And so it's a much higher quality, much more comprehensive manual. And I would really highly recommend that everybody take a look at it. Because it does contain a lot of answers to questions that come up. Back in 2009, they made a few changes. The biggest change was that prior to 2009, you were allowed to accept an identity document that was expired. The theory being that it still showed someone's identity, even if the card itself had expired. But in 2009, they changed that, and they said from now on, going forward, you can only accept current, valid, unexpired identity documents. And so that matters because when you're looking back at your I-9 forms, prior to 2009, you might see where somebody took an expired document, and back then that was okay. But nowadays it wouldn't be. Okay, I do a lot of I-9 audits for companies, and so in the course of that, I'm able to see the common mistakes that come up. And when you do a lot of these, you start to see the patterns and trends, and it's really just the same errors over and over again for the most part. And so what I've done is made a list of the top 10 errors and mistakes and issues that I see come up, and we'll just run through those top 10. The most important one that I see is sometimes there just aren't I-9s for some employees. It could be because you have a facility in another location without very much HR oversight, and so individuals get hired and nobody does the I-9 for them. Or it could be that they went through orientation and it was a busy day and just didn't get to it. We don't know why, but sometimes you look at the I-9s and they're just missing I-9s. Of course, sometimes you'll have a company that they just don't do it at all, and that's problematic. But a missing I-9 is a very serious kind of violation that can't be corrected after the fact. If you employed someone, say somebody started 4 years ago, you didn't do an I-9, and today you discover it, then for that 4-year period, there is a violation, and there's no way to fix that retroactively. But what you can do is realize the error, do an I-9 today, and that brings you into compliance. And then if there's ever an I-9 audit, you will get a fine for the period that they didn't have one, but that fine amount could be reduced because you brought yourself into compliance. So it's one of the most serious types of violations, but there is a way to try to mitigate the damage. Number two, we see I-9s that didn't follow the proper timeline. So remember, when you hire when you hire an employee, they must complete Section 1 of the I-9 on the first day of employment. And then you must complete Section 2 by the end of the third day of employment. And by the way the government counts, if somebody starts on a Monday, the end of the third day would be Thursday evening. And so it gives you, maybe an extra day, the way they count. So what we see there is we'll do I-9 audits, and we see a beautifully filled out Section 1, because the person hired in, they went through orientation, they filled out Section 1, but then Section 2 is completely blank. And that's typically because the employee didn't have the documentation, or HR didn't circle back with them to do Section 2. But I think probably the most common scenario is the person says, oh, I don't have my driver's license, or my social security card's at home, or something like that. And then they just never bring it in, and HR forgets to follow up with them. So Section 1 problems are created by the employee, but they become your problem because it's your fine if you don't catch it. Missing Section 2s or other Section 2s are really HR not having a system where someone is accountable to follow up. And so you want to make sure that you have some central accountability, so you can either get the employee to do what they need to do, or do in Section 2 what you need to do to get the form completed on time. Number 3, the receipt rule. So there is a rule that says if somebody normally has a document, let's just say, for instance, a social security card, but it was destroyed, it was lost in the fire, or somebody stole it, or something happened to the card, they can go and apply for a replacement card and present the receipt for that application to you as kind of a placeholder for that actual card. And you're allowed to then use that and let them work for 90 days while they're waiting for their social security card, for instance, to come through. And so that's a pretty straightforward, easy rule. Somebody can go apply for a replacement, use the receipt for 90 days. It's your duty to follow up with them within the 90 days and make sure they get the actual card, and then get that into the I-9. But where the confusion comes up is people will call and say, well, so-and-so, we want to hire somebody, and they have applied for a work permit, but they don't have it yet, but they gave me a receipt. Can I use this receipt? And the answer to that is no. The difference there is that individual didn't already have a work permit that they're trying to replace. So the question is still there as to whether or not they qualify for the work permit. And so receipts can only be used for already existing documents that were lost or damaged or stolen. And the second thing to keep in mind there is you really must set your own tickler to follow up with the employee, because so often they go and apply for it, they get the document, and then they don't bring it back to HR, and then you pick up a fine after the 90th day. Number 4, this is an anti-discrimination issue where sometimes employers are tempted to tell the employee which documents to bring in, and we don't ever want to do that. You just want to be neutral about it, present the list of acceptable documents, and let the employee choose which one document or which combination of documents that they would like to use. The concern here is if someone comes to you as a new hire and they appear to be from the United States, then they sort of get the easy treatment and you take whatever documents they present. But if somebody comes and they appear to be foreign, either because of the way they look or the way they talk, or because English is a second language, or something of that nature, then the temptation is to over-document them, to require them to show a green card or something like that. And you just don't want to do that, because there are so many different combinations and scenarios out there that you really have no idea what somebody's going to be able to present. And you don't want them to perceive, accurately or not, that you're not going to hire them or let them work unless they jump through just the right hoop and show you the exact document that you're looking for. Number 5, keeping copies of verification documents for some people, but not for all. This is an issue too, that the concern is when somebody looks or sounds foreign that you'll really run them through the ringer with the process, and we want to avoid that. And so my advice to companies is to make a copy of the documents that they show you and save that copy, because later on, if you get an audit and that employee is not cooperative or they're no longer around, if you've got copies and you've got errors on the I-9, you'll be able to look at those copies and make corrections on your I-9s and maybe avoid some fines. But if you didn't save the copies, then you don't have anything. You have to go back to the employee and get their cooperation. And if they're no longer with your company, they're not going to cooperate and you'll get a fine. But whichever way you do it, whether you don't keep the copies of documents or you do, you want to make sure that you're consistent across the board throughout your entire organization. so that you don't give an opportunity for somebody to say that it was discriminatory the way you chose to keep documents or not keep documents for some people. Number 6, throwing away your I-9s too early or too late. And so the key here is really just to know the retention rule. You must have an I-9 on file for all of your active employees. There are a few small exceptions. If you have an old-timer employee who hired in before 1986, then you don't have to have an I-9 for that person. And there are some other exceptions around national security, if that's your area. Some people don't have to do an I-9. But for 99.9% of employees, you need an I-9 on file for every active employee. And then when an employee separates from the company, there's a retention rule for a period after they're gone. And that rule is 1 year after they terminate or 3 years after their date of hire, whichever one is longer. So if you have a very short-term employee that hired in 4 months ago, and then now they quit, you'll be saving their I-9 for 3 years from the date that they started working for you. But if you have a longer-term employee, then it's only 1 year after their date of termination. Beyond that, you don't want to save the I-9s because they're just a source of liability. And so if you're sitting on I-9s that you didn't have an obligation to keep anymore, and then you get an audit, there's a potential for the immigration enforcement to take that into consideration when they find the errors. Number 7, the employer fails to re-verify expiring immigration documents. So for U.S. citizens, lawful permanent residents, and U.S. nationals, people who were born in U.S. territories like Guam, for instance, all those people have permanent work authorization. So you'll fill out the I-9 form for them one time and then you're done, and you won't re-verify them. But other people who come here temporarily on some kind of temporary work visa, they check the 4th box down in Section 1, which says, I'm an authorized alien, I'm authorized to work. And they'll have a temporary date that their authorization ends. And so those individuals, on or before that date, you need to go back and see their new documents, their new basis for work authorization, and then re-verify their Form I-9. This can become one of the most serious violations if you miss it, because the way the government looks at it is, if you hire somebody and they have work authorization until, say, December of 2014, and in January of 2015, they're still working for you, and you haven't gone back and followed up with them, then right there it is in black and white. You knew when their work authorization ended, and you continued to employ them, so they've sort of got you on the knowing unauthorized employment, which is the most serious violation. Again, you want to set your own ticklers. Do not rely on the employee to come forward and tell you when their visa is expiring, because they often won't. And so it's a violation for them too to work without authorization, but you'll get the fine for it with respect to the I-9. And then we have sort of the related issue of number 8, which is re-verifying the I-9 when it's not necessary. Sometimes HR people will do their own self-audit, and they'll find I-9s that were completed many years ago and completed correctly, but then the documents expired in the intervening years. And so they think, well, I've got expired documents, so I better go back and re-verify. That's never the case. There's never a reason to go back and re-verify the work authorization of someone who's here permanently. However, if somebody comes to you and says, well, my name changed because I got married or divorced, or I just changed my name, then you can ask them, well, why did that happen? And tell me more about it. And if they want to give you a document like a marriage certificate or something, you can put that in the I-9 file. And there is a space down in Section 3 to re-verify for that kind of situation. But you're really just updating their name, not their work authorization. Okay, number 9, typical mistakes that I see on the Form I-9. This is just sort of a hodgepodge category of things that really come up often. The biggie is forgetting to sign. I don't know why, but people just forget to sign the form. Either the employee forgets, or the employer forgets, or they sign it but then they don't date it, or they date it and put their birth date instead of today's date. And so these are just really common things. For Section 1, you want to make sure after they're done completing the I-9 in their section that you look at it, make sure it's completed correctly and signed. We also see situations where the employee doesn't check a box in Section 1, and this could be an inadvertent. Maybe they just don't know which box to check. but it could be intentional. And the reason why is if someone has come to you and presented, for instance, a fake Social Security card, and they're claiming to be a U.S. citizen with that Social Security card, when they get to that box about, where they have to claim, am I a U.S. citizen, am I a permanent resident, they don't really want to check it because a lot of people know that that is a crime to claim falsely to be a U.S. citizen, so they'll leave it blank. And that it can be an indicator that, that you have someone using a false identity with you. And so if that happens, if somebody doesn't check the box, you just want to check back with them and say, hey, I noticed you didn't check the box. Can you indicate, what your status is? And then you want to compare that with the documents they've given you. If you hire me and I present my green card to you, and then I claim to be a U.S. citizen, there's an inconsistency there. And the Immigration Service will expect you to notice blatant inconsistencies like that. And if you don't, they'll say that you didn't behave reasonably when you completed the I-9 form, and you can get a fine, or they can try to say that you knew the person wasn't authorized to work. And then also a big common issue that I see is just having the wrong document and the wrong column in Section 2. And that just comes from people, I think, being in a hurry and not reading the form closely. But you want to really know that form and understand that List B is for identity documents and List C is for work authorization documents. And if you're ever not clear about that, you can look at the last page of the Form I-9, and there's that chart that shows exactly which documents are identity and which ones are work authorization. If you're doing a self-audit and you realize, oh, these are in the wrong columns, you can just make X's and draw arrows to show the correct column that it should have gone into. And then number 10, finally, demanding a Social Security card. So keep in mind that an employee doesn't have to show a Social Security card if they don't want to during the I-9 process. And so taking it step by step, in Section 1, there is a field for Social Security, for the Social Security number, but they don't have to complete that field if they don't want to. And so if they don't put their Social Security number up there, you can't require them to. You just go ahead and leave it blank. Down in Section 2, they might present a Social Security card as proof of their work authorization in List C. And if they do, then you need to see the original card. But they might not. They might present a passport or some other kind of document instead of a Social Security card. And so it's possible for a person to get through the whole I-9 process and never show their Social Security card. And if that's the combination that they present to you, then that's just what it is. And you shouldn't try to require them to show the Social Security card unless you're using E-Verify. If you're registered for E-Verify and using it, then you must know at least the Social Security number. You don't necessarily have to see the card. You have to know the Social Security number so that you can put it into the E-Verify system. Okay, so those are the 10 most common issues that we see. Also, sometimes people will ask me, how does an I-9 investigation work? And typically what happens is you'll get a notice in the mail. Sometimes they come in person. But you'll get a notice telling you that you've been selected for an I-9 audit and that you have 3 days to respond, and that you have the right to waive your 3 days if you want. So it goes without saying you should never waive the 3 days. You want to take that time to get yourself in order so that you can present the best response possible to them. And the first thing that you should do is contact your attorney to help you prepare the response, to communicate on your behalf with the agency. Sometimes an attorney can help you get more time if you need it. And then the second most important thing about that is remember to make photocopies of all your I-9s and any documents that you turn over to the government, because the government won't make photocopies and they won't give you any kind of receipt of what you've provided. And so it's really up to you to make your own photocopies. That way later on, if you end up in a dispute about what was provided or not provided, you'll have proof of what you had in your files at the time that you gave it to the government. People ask me what triggers an I-9 investigation. First and foremost, I can tell you that they're not done at random. They are done primarily by demographics. If you're in certain areas like construction, roofing, if you're operating slaughterhouses, areas like that where they believe that there's going to be a high percentage of undocumented workers, then there's a higher chance that you're going to get an I-9 audit. They also come on the basis of tips that people receive. that the agencies receive from, it could be from customers, from disgruntled employees, from competitors. And then we've also seen cases where an employee gets into trouble on some unrelated criminal matter, and during their interrogation, they start talking about all the people they know at work that are undocumented, and they're trying to reduce their own, criminal penalties. And so sometimes that will get referred over to the immigration authorities and trigger an I-9 audit. And then finally, the best things to do to prepare for an audit. Well, the most important thing to do is to self-check your I-9s. But understand too that probably alone won't be enough, that you need somebody to come in from the outside periodically. They recommend every 2 to 3 years to have an attorney or somebody that really knows the I-9 compliance procedures to come in and take a look at your I-9s and do more of a deep look at not just the I-9s themselves, but how do they compare with your whole I-9 compliance regime. Do you have a written policy? Do you have frequent trainings? Compare your I-9s against a payroll run to identify if you have any missing I-9s. And then also, once the I-9s are evaluated, to put them in some kind of a format so that you can look for patterns and trends and identify your Section 1 errors or your Section 2 errors, that sort of thing, so that you know which areas to train in. That'll do two things. One, it will hopefully help you reduce future errors so you keep your fines down. Also, it shows good faith attempt at compliance. So whatever your fine amount is, they can mitigate or aggravate up or down based on the circumstances. And if you've got a strong showing of compliance, they'll probably mitigate down, and they can go down as much as 25% for your overall fine amount. And so I believe that's it. If you have any questions, you're welcome to call or email me, and my information is provided on the slide. Thank you.